This program is brought to you by Emory University.
Welcome to our keynote panel. Thank you for all of your wonderful presentations yesterday, and we look forward to a really full day today. I'd like to begin by introducing the members of our panel. On my immediate right is Barbara Wagner. She is an assistant professor and the director of the Chase Small Business and Nonprofit Law Clinic at Salmon P. Chase College of Law in Northern Kentucky University. Before joining Chase, Barbara practiced law for over 30 years. She's currently a member of the Business Law Education Committee of the ABA Business Law Section and is co-chair of a task force on competencies for business lawyers. This is Barbara. And to Barbara's right is Anne Marie McGackie. She's a partner here in Atlanta at McKenna, Long & Aldridge. She focuses on general corporate representation of publicly and privately held companies in a wide variety of industries. She is co-head of McKenna, Long & Aldridge's Mergers and Acquisitions Group and the Atlanta Hiring Partner. She's also on McKenna's Professional Development Committee. To Anne Marie's right is Bill Bates. Bill retired from King & Spalding in New York in December of 2013. He was a partner in the corporate practice group and co-head of the firm's merger and acquisition practice. And he served on the firm's lawyer development committee for 13 years and as chair of that committee since 2005. He also served on the Associate Evaluation Committee for 2 terms. And then to Bill's immediate right is Danny Bogart. He is Associate Dean for Academic Affairs at the Dale E. Fowler School of Law at Chapman University, where he holds the Donnelly and Marjorie Bollinger Chair in Real Estate Law. His interests are primarily emphasizing transactional practice. He has an upper-level book on commercial leasing that some of you may be familiar with, and he has actually co-authored 5 books, including the most recent, Property Law, Practice, Problems, and Perspectives. So those are the members of our esteemed panel, and I'm thanking all of them in advance for agreeing to do this and for being here with us this morning. The title of our panel is Skills is Not a Dirty Word, Identifying and Teaching Transactional Law Competencies. Perhaps it should have been competency is not a dirty word, but it didn't sound quite as sexy, so didn't call it that. When I was getting ready to moderate this panel, I was trying to find out what was the origin of the word competency in the context of developing talent. And it's attributed in many places on the internet to a psychologist named David McClelland, who wrote a paper in 1973 called Testing for Competence Rather Than for Intelligence. And he wanted to find out why, if everything is equal, if people are equal in intelligence and all other ways, why some professionals wind up being more successful than others. He believed that there were certain specific common abilities that successful individuals had or possessed, and he called those core competencies. He thought that they also could be identified and that they could be taught. So according to McClelland, competencies are skills and traits that top performers demonstrate most often. With that, I'd like to begin with our panelist, Barbara, and I wanted to ask her about the ABA's focus on competencies.
Okay, well, thank you, Sue. Let me say that I'm on a very small cog on the task force that's part of the Business Law Education Committee of the Business Law Section. I can tell you a little bit about what they're doing. I am not an expert on everything the ABA is doing, which ranges from the recent report of the task force on the future of legal education. There are a lot of other people looking at this, so I'm not an expert on everything. What I can say is This task force met at the Business Law Spring Meeting in Los Angeles and had a discussion that's listed. I pulled together the handout. It's listed, can they be defined, and it was competencies for business or transactional lawyers. Can they be defined, and Todd, and if so, who should do that? And all we've done so far is decide. We haven't even decided who should do it, but we have at least decided to go forward to figure out how far can we define them, and then we get into who all is involved in defining and who's involved in teaching. The materials I pulled together, which was sort of on short notice, I've seen a few interesting typos, I apologize, but they are by no means exhaustive. I wanted to give them to you to read at your leisure. I'm not going to go through them in any detail, but it's a selection of how different people have looked at and defined competencies, some of them specifically for business and corporate lawyers, and others that are much more general. I do want to point out two things. I believe from most of the people I've spoken to that the competencies on page 3 by, what are their names? Marjorie Schultz and Sheldon Zedek, if I'm maybe pronouncing that wrong, and this is actually a page copied out of a Bill Henderson article. I think many people think that's a good listing of competencies for lawyers generally, but not specifically for transactional lawyers. And the other thing that I don't think will come as a surprise to anybody, but on page 7 at the bottom of the page there is a interesting chart put together by Eric Talley, who's a professor at Berkeley Law School, and he was testifying to the California Bar Association, which is looking at defining competencies, and everyone should be aware that lots of states are looking at them separately from the ABA. What was the most interesting to me was his slide at the bottom of the page. What's your degree of support for efforts underway to mandate minimum skills competency training for law students? He had a relatively small sample. It may not be statistically significant, but if you look at, for each one of the categories, the right-hand column, which is academics, it's basically a reverse bell curve. So they were either very strongly positive or very strongly negative, and anyone in the middle was not as highly represented. So just real briefly, my thoughts about competencies. There are lots of different ways to define them. I think some of the other panelists have different experiences that they will share. But I think depending on who you're reading, they range from things that are really part of your nature and makeup, which may be revealed in a Berkman or a Myers-Briggs evaluation. We all know people who are either very litigious or very much interested in making a deal. And there may be a lot of things that you learn long before you go to law school, or at least could, such as anything from skills like Excel to good English composition. But the other thing in the area of competencies, I think some people define them and look at them as the title of our presentation as very skill focused. It could be how to do blacklining, how to write a business letter. Some of them focus on traditional legal doctrinal areas, and one of the presenters at our program in the spring basically said, nowadays there's so much law students need to learn. He said, let the students learn as much doctrinal law in law school and let the law firms worry about training them. I think that may be true at the top 50 or 100 or 200 law firms, but I teach at a law school where that's really an aspiration for very few of my students, and many of them either go to 1 or 2 person firms or hang out their own shingle. And so I think I think we have to think about what each law school has to define differently who their students are and what competencies they need. There's certainly other substantive areas that are not typically part of the law curriculum, such as accounting and finance. That may or may not be a competency, but it's certainly a knowledge area that students and practicing lawyers need. Then there are the real practice-ready skills like contract drafting, project management, oral presentation, and broader skills that can go from ethics to how to run a law office to client development and managing a workload on a given day. I do think one of the issues that everybody has to think about, we can't focus just on what you teach in law school or what do you teach in your first or second year, because I think it's really a developmental thing. that there are really differences for more senior lawyers and more junior lawyers, and we have to be mindful that some of our law students are not going to be going into practice. Some not, some by choice. So if we tell them they all have to learn certain particular skills and they want to go be a lobbyist or do something totally unrelated to actually practicing law, we can't force too much down their throats that won't have more broad appeal. And so I think my main takeaway is whatever we come up with in terms of defining competencies, we have to realize that there's, no one size fits all.
Thank you. Can I ask just one follow-up question? What is the task force going to do next?
Well, the business law section is now starting to meet 3 times a year. I'm not sure I will personally get funding to attend that many meetings. But the task force, we're trying to pull together a summary of what was discussed and what came out of our meeting. We had a list of people who were physically, present in Los Angeles. If anyone in the room is interested in getting involved, feel free to let me know. I think what we will do is start circulating, within hopefully a small working group, a list of particular, areas, defining exactly how far we want to go, how broadly do we want to define this. Are we focusing on competencies in terms of law school? Are we focusing on competencies in terms of, lawyers in their first 5 years? And how broadly do we define business law? Because, someone who does just real estate is going to be totally different from someone who does M&A work in a major city versus someone who does a general practice in a small town where they may do anything from a residential real estate closing to a bank loan to, whatever else, drafting a simple contract.
Anne Marie. Thanks, Barbara. Anne Marie, I know McKenna Long's been using a competency model for evaluating its associates for a while. I wonder if you can talk about why you started to use that model and how you developed it.
Sure. Thank you for asking me to participate. We decided at the firm several years ago that as part of training as well as evaluation process for associates, we should make it as objective as possible and not have the subjectivity that you may get if you don't have clearly defined objectives for associates to meet as they advance. Our evaluation process previous to this was based on evaluating associate whether they met expectations, exceeded expectations, or did not meet expectations. And the expectations was the subjectivity part. Some partners are known as hard graders and some are easy graders, probably not like professors. And maybe students steer toward the easy professors and not the hard professors, depending on their personality. And at a law firm, you're kind of stuck with, who you're assigned to. And so we wanted to have clearly defined objectives for them to meet. So we came up with this. There was a large firm in Texas who had started this. I think we may have been one of the first in our region. It took a lot of time. At a law firm with a lot of partners, it's always hard to get consensus. I'm sure professors agree on everything when they're determining curriculum. And so we had many discussions, and what we decided is we would have firm-wide associate competencies. And the firm-wide associate competencies, every associate in the firm, not sure how many we have now, but probably close to over 200, probably close to 300. Would meet those competencies. And then we have competencies at a department level. So the corporate department has its competencies, the real estate department, the litigation department, our IP department, and our government department. Each have their competencies. Then within the corporate group, I can't speak for other departments, but we have a few specialty areas like tax. So the competencies for a tax associate would be a little different. If you weren't a tax associate, you wouldn't be required to, know the details of a 338H10 election. You would have to know what it is, but you wouldn't be responsible for making sure that the client gained that benefit. So it sounds like a lot, but it's Each of those competencies has 4 levels. Our associates, we've moved away from you're a first-year associate, you're a second-year associate, you're a third-year associate, and sort of the lockstep compensation. This was also then reflected in our compensation system, that you would be either a level 1, a level 2, a level 3, or a level 4. And you would have to achieve substantially all the competencies within level 4 to make partner. And that also helped when people say, well, what does it take, to make partner? You would get all the associates receive the competencies in writing from day one. So it's not, you don't get to see level 1 or level 2 until you've reached level 1. They have all of them. And that's, we've also got buy-in from our associates committee, was part of putting the competencies together. The firm-wide competencies are divided into 5 categories. We look at, there's a skills category, client service, work management, interpersonal traits, and firm citizenship. And then within each one of those, there are subgroups, and I'll just give you an example. So under skills, written and oral communication would be a skill. Under interpersonal traits, teamwork and cooperation would be a competency. And then within the department, they are actually, specific. A level 3 would be required to draft a legal opinion with very little editing. A level 1 would be required to know how to form a corporate entity. A level 4 would be expected to have at least 1, maybe 2 small clients where they're considered the go-to lawyer. So it's broken out almost as a roadmap, and it helps us in the evaluation process be very specific in what training they will need to move forward.
Thank you. Bill, at King and Spalding, I think you used the competency models a little differently.
We did. Part of it is that, I'll give you an example. When I started practicing, before most probably were teaching, I was assigned to matters that the client would pay for me to do. Those no longer exist in the modern world. And so we basically, from a training and development standpoint, wanted to spend more time making sure our associates got valuable experiences and developed it as good lawyers. So ours basically developed at the practice group level, and started with 1 or 2 practice groups at the firm, and then as best practices, the Lawyer Development Committee recommended that most practice groups develop, and most use them to a greater or lesser extent, and they often combine them with work coordination. But what we tell people when they use them is they're not for evaluation, they're not a guarantee that you'll get assignments for each of the types of matters on the list, because that's always client-driven, and no assurance that if you do each of the matters or the types of matters that you will be assured of promotion. But what the lists do is they set forth skills, experiences, aptitudes, behavior, and personal characteristics that help one develop into a strong lawyer. And basically, while each practice group, I said, has a different skill and competency list, if you looked at them, they obviously were drafted from a similar template, and they tend to be junior, first and second associate, and then mid-level. We really don't focus on the senior level, because by that time, you really need to be running deals and have accomplished most of what was on the first 2. And if you look through the materials that were handed out, the categories are often different, but the broad categories, when I sorted through ours, were general legal skills, professional work habits, interpersonal skills, work skills, firm and community involvement, and external profile. The latter 2 are something that tends to be more, well, you can always become involved in the firm activities as a young associate, but obviously external profile takes a little more seniority as you practice. And just to give you an example, the general skills include intellectual curiosity, things as intellectual curiosity, basic knowledge of the industry, as you start working with clients, specific knowledge of your client. One thing, I went to the University of North Carolina Law School. in Delaware, corporate law hadn't been as well established as it is now, but understanding Delaware corporate law and the law of the jurisdiction in which you practice has become very critical, and that needs to come from a very early stage, and then understanding basic documentation and basic research and drafting skills. Professional work habits, I used to think you didn't need to teach people this, that law students particularly are very gung-ho, but, and telling people that they need to be available 24/7, that they need to return voicemails promptly, they need to check their email and respond promptly, whether it's a client, a partner, or another colleague in the firm. You need to learn how to make decisions appropriate to your level. I mean, we encourage people to take initiative, but a first-year associate isn't going to make a structural call on transaction. We expect people to take ownership of the matters. Obviously that's a learned technique, but we expect you come in with basic organizational skills, and simple things like the bane of most lawyers is timesheets, but making sure people do that on a timely basis. Interpersonal skills have become even more critical as time has gone on. That includes such things as being courteous with staff, clear communication skills, ability to interact well with clients, and be able to work cooperatively and constructively with others. Firm and community activities, involvement in firm activities, you can get involved in your practice group. What's become more important these days is business development, and firms are all the time responding to requests for information or requests for proposals, and associates can play a great role in that. Work skills. Now there's some handling closings. There's no reason a first-year lawyer shouldn't come out of law school, frankly, knowing how to handle a closing, what a closing is. Drafting basic contracts, and in our list, we'll sometimes list the specific types. So you start off with a shareholder agreement, then you do a purchase agreement, you do a complex merger and acquisition agreement. It varies. In like Energy Group, we have standby purchase agreements and the like. Ability to identify and structural issues, and again, that is something more prevalent in the mid-level than the junior diligence skills. And then we actually have modules that teach delegation and feedback, and we actually present those to summer associates in the sense that while you're not giving feedback, it is important to learn how to take feedback. Professional development, obviously developing a public profile if you want to be successful in the practice of law. And Sue had asked me how we do that in recruiting. We don't really use this competency model in recruiting, but there's some similar concept that when we look at first-year or hiring first-year lawyers, one is obviously academics, which is a given, but we start looking, because we found these traits to be important to successful lawyers, demonstrated leadership skills. I mean, it's easier if you've had some work experience, but even if you haven't, in various student activities, demonstrated cooperation, the ability to work with others, and then establish problem-solving skills, because you don't all of a sudden become a problem solver the first day you become a lawyer. So,
thank you. And now for an entirely different perspective, Danny, at the end. There's been all kinds of talk about creating competency modeled curricula. And Danny, you're a dean and a professor. So maybe you'd like to tell us about what you've been doing at your school as far as curricular review.
Thank you. First of all, my initial reaction to this kind of panel is that there's a time for professors to talk, and then there's a time for us to sit back and listen and absorb. And for me, I fall into the latter category here. When attorneys are talking about what they look for in students who have graduated, what they need out of those students so they become successful lawyers, it tells us essentially, what we should be shooting for with outputs. And it's a reality check in many respects. The problem for me as an administrator, and you asked about the school, so it's now got a name, the Daley Fowler School of Law. We received a nice gift, so there's a name, and there's a beautiful large portrait of Daley Fowler and a bust as well. And we're very pleased to have it. But one of the things that we have encountered, or we engaged, I suppose, over the last several years is a real review, a curricular review of our entire academic program. I'll say this for the faculty in the room, short of tenure and promotion, and perhaps appointments, nothing draws out emotions in the way that a curricular review will do so, because it touches upon what faculty do on a daily basis, how their courses are constructed, what is expected of them, what is deemed to be useful to the school. It's a statement about where the law school world has gone and where the legal world has gone and whether they're in touch with it. And if you've been teaching small seminars for many years on esoteric topics, only to be told that, in fact, that's not what we should be doing. It can be a rather arduous process, and we engaged it. I think everyone came to it at our school in good faith, and we resulted in what I hope will be a good program. The second point is that it's any kind of curricular review, and I'm going to talk about my specific reactions to what people have said here, but I have to say this. Every academic program is a work in progress. And if you engage in any change, individuals on your faculty are going to be thinking, this is a risk. I know what I've been doing. You're asking me to take a risk. I'm not sure it's going to be successful. These kinds of events, and I'm heavily in favor of them, which discuss, in my case, I've spent my academic career working on teaching transactions. But that's been an uphill battle. When I began, and I was asked to show as a young, looking at my first job, a writing sample, and I showed them a mortgage that I'd helped to revise, they looked at me like I was crazy. You know, what is this thing? They were all litigators with very little practice background in litigation. This document was entirely foreign to them. The world has changed and gotten better. All right, so let's start with the big question is how to translate what you've just heard into a program. So you've heard a number of things. One of the things you've heard is that the law firms want individuals, I've now heard this now several times, was an ability to deal socially with their clients, that is to interact in an effective manner, to interact effectively with their colleagues, to solve problems, not just to write clearly, but to speak and react clearly, to react in a way which seems judgmentally sound. What do we do in law school that helps students achieve that, say in my class, a first-year property course, or most classes for that matter, in which there is doctrine and an exam at the end? Translating what you've just heard into an actual academic program implementation is the hardest element. And it may be the reason why a good bit of this is relegated to law firms and to practice, because it is very hard to actually do this in the four walls of a law school. Let me give you a couple of other comments, and I'll talk about the act, and I know I have limited time. There are numerous pressures that are focused on a law school and its faculty at any given time, and I'm going to leave aside the economic aspect, which is the changing marketplace, the reduction in class sizes, the reduction in application levels to a level close to 1975. I mean, it is amazing the degree to which applications have contracted. Everything has changed for our economic model. If you view law schools as a business, it is not the business it was 5 years ago, 10 years ago. It has changed. That's one huge pressure, but it's not one I'm going to point at. I'm going to point at another one, which is the Department of Education and the regional accreditation agencies. In our case, it's the Western Association of Schools and Colleges. It will be different accrediting agencies around the country. It is not simply the ABA. When our accrediting agency comes to the university, not to the law school, it demands learning outcome assessments. That is, it demands that each individual unit, including the law school, show in every syllabus and in every course that it has identified learning outcomes, that we actively assess them. It is a separate pressure from the law school world, and we must meet it. This is why, for example, although there is some overlap, we have identified at our school, as every school will do so, those things, those objectives, say client counseling, in our case, legal writing, and doctrine. But that's really a very small core of what law schools should do, but we must meet those elements in every single course. To some degree or another, we must show how. When I think about so at our school we had a traditional, because we're relatively young, we had a very traditional curriculum. The ABA more or less requires that when you start out. You must have that traditional first-year curriculum and so on. You must have a writing requirement. And by the way, a writing requirement is an admission of failure. If you must have a writing requirement in your school, let's say one course for practice writing and maybe one course for scholarship, what you're really saying is in all the other courses you're not doing it. But we'll guarantee that our students graduate with one writing requirement. If you think about it, if every course had writing in it, you would not need that. It's a failure of law schools that we have these kinds of requirements because it's not incorporated into the daily thing of what we do. We've tried to reach to this in a different way. So although we have a heavy set of requirements of the school, we have done several things. The first is that we now require that all students graduate, again, it's writing, but a practice writing-oriented requirement, 2 such courses. And those courses require each student to deliver, I know this because it's part of the student handbook, and I know this by heart as an associate dean, that you must be, not only must this work look like lawyer work product, but it must be something you could show an prospective employer. So in my commercial leasing course, what they might show is a lease review, which is 10 to 15 pages long. This is something that a real estate lawyer would say, oh my goodness, I haven't seen a student prepare this. No, it's not the quality yet of a first-year associate, but it's not something that we're used to seeing coming out of law school. In order to get a student ready for that, however, we decided that that's a fairly upper-level skill. There needs to be a springboard, and one of my colleagues, David Gibbs, is here. David's been working hard on a course called Practice Foundations Transactions, which we hope will be a requirement within a year to 2 years for all second-year students. The idea is to be able to take an M&A course. It would be nice if you knew what a rep and warranty was, if you knew the basics of certain types of drafting, if you knew the order of a closing from front to back, which would be the same for a small commercial lease as it would be for a large M&A, although obviously one is more sophisticated than another. We will be we're not requiring, we are adding a type of course, which we will call, for lack of a better word, and it sometimes gets a bad rep, that word, but a lab. So our M&A course, for example, is taught by a man named Tom Crane, and Tom's a wonderful guy who was the managing partner of Rutan and Tucker in Orange County, which is probably the largest regional firm. So the course, or actually, rather than use securities regulations, also Tom. Susanna Ripken, who's our professor of securities regulations, very doctrinally rigorous course. She continues to teach it that way. Tom will teach a 1-hour lab that goes with it, which incorporates securities assignments, securities regs assignments, private placement, whatever, at the appropriate moments throughout the course. So the doctrine and the integration of skills occurs, but the recognition is that you need a sophisticated practitioner to help you with this. And that's the second point I would make, which is we don't always have the right army when we're going to war. The people who are our faculty right now don't necessarily have the practice skills, don't even have close to the practice skills of some of my colleagues, nor do I sitting at this table, all of my colleagues sitting at this table. Therefore, the demand that we teach these things is an interesting one because we're asking people who have not yet reached that level of mastery to do so, and that creates a huge problem for us. One which was hotly debated. How do you handle that? I could go on quite a bit. I would say our issue is I can listen to all of this. The problem is implementation, translation. How do you take this demand for a well-rounded individual who knows how to respond to clients? How do you teach that in the environment of a law school? I think clinics do it, for sure. We have decided that, and we have some wonderful clinics, we want to incorporate simulations, and we want our courses, our doctrinal courses, to include enough practice orientation so this is not a surprise to students when they get there. And then one last comment. I had a son who took baseball camp for about, I don't know how many years. And I'm right now, by the way, melancholy because he's going off to college and it's the end of baseball. At this camp, you had, and baseball, by the way, in California is year-round. It doesn't ever stop. It's not like Georgia. It goes on all year with travel teams. In the summer, there's a camp called Mark Cressy. It's a great camp, a former Dodger catcher, whatever. Best thing he's ever done is this camp. You see these kids at 8 years old, and they start with basics. Now, you go back later, and you're looking at a kid who's 14, right before he's going to try out for high school at some of the best high schools. And the same training exercises on base running, everything else, they remain the same for these advanced kids. The idea of best practices. And I've always thought about the best practices for a law school. The best practices in understanding a deal and how to close one are going to be the same for a first-year associate as they are. And I think you probably encounter lawyers who did not understand them in their 10th or 15th year of practice. I think the goal for a law school should be to expose students to some of those basic practices and best practices with the understanding that we will get nowhere close to mastery. And that's what I would say.
Thanks. I want to turn this over to the audience for questions and answers, and I wanted to add one thing. Anne Marie, if you would. talk a little bit about your talent assessment program that you use when you're recruiting.
Yeah, so before you evaluate and before you train, you have to hire. And at the same time, we looked at our hiring process and said, we're looking at, great kids with great grades and high ranks, and everyone's on law review and president of this and involved in this. How do we kind of translate what somebody said, if on the competency side? So while we don't test for competencies, we do have our recruits take a talent assessment that's done by a third party. And the way we came up with it was determining which traits made an associate successful at our firm. So it was specifically designed for what we were looking for. And the categories that it assesses are work management, team player, driven, and judgment. That's what we are looking for, and so the partners that are part of an interview schedule have specific questions to determine whether that candidate would be have the one of those traits that we were looking for. So, for instance, if they take the assessment and it seems that team player, they may not be strong in the team player category, a question that you could ask, and we're given 4 or 5 different questions to elicit a response in any one category. But the question would be, what team have you been a part of? What role did you play on the team? What did you do to fulfill your role? Tell me about a time that you worked on a team and not everybody pulled their weight. What did you do? That type of thing. And I was very wary of having this assessment. I've been on the recruiting committee, I think, as soon as I could qualify. I took a brief respite when I had my children, and it was long enough to get back on when I came back. And I just thought that was not, you can't assess somebody by giving them a 30-minute or 45-minute assessment. Well, the partners took it, including myself. And I got the results, and I looked at it, and I said, oh my God, this is me. I sent it to my parents, and they said, oh my God. And so was it 100% accurate? No. 80%? Yes. And so if it shows that someone might have a substantive, deficiency in work management, as far as, which would mean balancing priorities, you ask the question, and it helps us, all things being equal. I mean, if you're in law school and you're doing well, you're smart. We're not testing IQ. If you're smart, you can figure you can figure it out. But it's been very helpful, and I also thought that associates or candidates, law students, wouldn't want to take it, but they do. I mean, if we could text it to them, they'd probably take it even faster. So, I mean, they take these things, they turn it around, they don't ask questions, and, I said, well, if somebody isn't going to take it, then we're just not going to hire them, and they're all taking it. In fact, we have people that aren't even applying for jobs at our firm that want to take the assessment. So it's been, for us, it's been a real asset.
Thank you. Can you just repeat what those 4 categories were?
Sure. Work management, team player, driven, and judgment.
Thank you. Okay, so we have 2 microphones out in the audience there. If you have a question, I ask that you step up to the microphone, identify yourself, and ask your question. Here comes somebody.
Hello, my name is Todd Starker. I'm from The Ohio State University. I see at our school courses that would seem transactional, wills, trusts, and estates, or even mergers and acquisitions, still taught with traditional case books all through analyzing cases and the Socratic method. I would argue these are more litigation courses where the subject of the litigation is a transaction. Would you support, at least for some percentage of the curriculum, sort of ditching the casebook method and ditching to the Socratic method and really teaching more of the transactional skills?
Maybe Danny and Barbara.
Okay, well, I'll answer that question. It's funny that you mentioned those two specific classes. This last year, we began the process with wills and trusts, although we did not do it with every section because it's a bar-tested subject. Students in California are, as they are at every state, but they are heavily focused on the bar. We have many sections of wills and trusts, but our primary full-time faculty member who teaches it is Celestine McConville. She's a wonderful, wonderful teacher. She taught it in conjunction with a man named Zeb Law, who's a wonderful adjunct who has a thriving practice in estate planning and wills and trusts. So we had a 3-hour wills and trust course, but they worked carefully to create a 1 hour, that's 1 hour a week for 14 weeks, 1 hour laboratory where students who were taking that class were also required to do the lawyer work product. Essentially, they would receive assignments, they would receive feedback, and they would go over it in class. And they spent quite a bit of time, and I gave a course reduction to the teacher to encourage her to take this, and she did. So this would be a well-integrated module. And so, yes, if the question is, do you ditch it entirely, the book, that's precisely where the faculties at most schools would say, no, I'm not ready, nor do I wish to give up this textbook. But you can encourage them to find alternative methods of incorporating practice and doctrine, and this was successful. It can be tweaked. We looked at it. I think there'll be things that we can do. M&A is another course. We hired, again, I mentioned him, an individual who had successful practice. But in hiring the adjunct, who's a highly successful lawyer, I said, and this has become standard for me now, your course must meet this practice writing requirement, which means, you can have a quiz or an exam, but the primary material on which these students will be graded, again, will be something akin to lawyer work product. And so you can have a text, but the material on which you will be graded needs to look like what a lawyer would do in practice and which you could give to that lawyer. These are courses students are wary of, by the way. They can vote with their feet. And so even if it's a successful teacher who's had tremendous success in attracting students in the past, students don't know whether they should take it. Add to it one element, which is that we have a required median at our school. And so the students don't, unless I give basically like a zoning variance, a variance from the grading, which I can do, they don't know how they will be graded. They have a sense when they take an exam of what's going to occur. They wonder if it's a 6-person writing course, what's going to happen. But yes, I would say that we have made an attempt to make these changes. But if you ask me whether personally I think we should be ditching it entirely, the answer is probably no. But I would say even more fundamentally, I don't think faculties would allow that. They can be encouraged into a somewhat intermediate or hybrid model, though.
Well, I'm a neophyte in the academy, so I would say, I mean, I run a clinic. I don't have a casebook. I don't. One of the first things I did when I was started teaching 2 years ago, was observe classes of some of the professors who've taught for a long time and see what they do well. And one of our best teachers, has taught traditionally from a casebook, but is able to use it in ways that really get, I've seen her try to get conversation stimulated in the class and turn even some of the cases they've been discussing into a clear, a lot of problem solving and what would you do if a client asked this. So I think as Danny said, we're a function of, a lot of law schools are a function of the people who are there, people who have their, are fairly well, practiced in what they do, and to say you have to throw everything out and start over is not necessarily going to be a very successful strategy, encouraging people to change. I personally, if I were asked to teach a doctrinal course, at least a textbook would, a casebook would make sure it covers the areas. I wouldn't want to try and design it all myself, but I'm personally a little scared of casebooks because I haven't looked at one since I was in law school myself.
I'd give you a bias as a 35-year practitioner. I don't understand why someone who takes an M&A course, or I also was a securities lawyer, security regulation course, doesn't have a very basic understanding of how deals get done. For securities regulation, people have never heard of Form 10Q or Form 10K, and they need to understand how those are put together and how you just do a form check on a client's 10K or 10Q. And then on the other side, the M&A transaction, M&A transactions, particularly public company M&A transactions, are pretty simple. I mean, there are only a few things you really negotiate, but I think students need to understand what those areas are. And I mean, I'm not discounting the doctrinal aspect. I think that is important, but just remember, by the time that person is making a call on a transaction as a senior associate or a partner, the law probably will have changed.
Yeah, I would just add that I think it's a hybrid. I think if you spend 8 weeks on what is a security, it's not really helping the students in all the cases. In the M&A world, you know, cases will look to Delaware cases, you know, sometimes for fiduciary duties or if there's some nuance that has changed. But for the most part, it's sort of the art of negotiation. And when we have recruits come through and they're deciding between corporate and litigation, I say, we don't draft any memos. You will not have to look at any cases. And sometimes that appeals to people and sometimes it really scares them because that's their comfort zone. So I think you do need to have a basic understanding of truly what is a security, because sometimes that's the question in a certain situation, but you also have to know what a Form K is and 10K and an 8K and, you know, the basic vernacular. So if you could kind of take the cases with what, you know, Danny said, if I had a recruit who knew what a representation and warranty was, they may not, you know how to negotiate one or how to draft one or even maybe how to revise one, but the fact that they knew what it was, you know, some of these kids don't know what 401ks are, so if they haven't worked. So I think it's a hybrid.
Great. Other questions? Oh, thanks.
So this is a fascinating panel and conference, and if it were possible, I would love to know what's the sum of all the years of experience in the room, because it's quite high. I mean, even up there, it's really quite astounding. So I have a question and a comment. So really, I congratulate you on having the law publishers here, the law school casebook publishers here. But I wonder, I'm not sure, are they in the room? Can you raise your hand? So they're not in the room. But if they were in the room, it would be quite interesting to see how that might influence their conversation with casebook authors. And especially, so I teach securities and business associations, and that issue of 10K and 10Q being, you know, primary, those are in the back, right? So pretty much all the casebooks start out with a 33 Acts still, for those of you who teach in this area. And what you're saying is, well, no, practice has changed, right? Of course practice has changed, the law has changed, but the casebook editors need to engage, I think, in a conversation with the authors, the publishers with the authors, and that might change things substantially. So if you all can talk to the publishers about what matters and ask them to talk to the authors in doing their revisions, that will help the teachers know what matters. Because as you know, some of us are pretty far away from practice, or some people have never practiced. And then the second thing is, one thing you haven't talked about, I think, is the difference between different practice settings and the kinds of competencies, skills, and knowledge that are required. Maybe the answer is there isn't a lot of difference. Doesn't matter if you're on your own or in a two-person firm or in-house, but on your own in-house, only one lawyer in-house versus working with 100 lawyers in-house versus working with King and Spalding in New York. Maybe it doesn't matter. Maybe you need the same experience. Maybe law school should approach all students the same way, but I would be interested in your comments about that. And I'm sorry, Carol Silver from Northwestern.
Well, I think there's a big difference between a large law firm, corporate law practice, and a small practice. I think the soft skills we've talked about are absolutely critical. Client development skills, if you're out on your own, are probably the most critical because you need someone to pay you. Whereas you come into a large firm and generally have an established client base that you can work into. So, but I mean, is that lawyer going to do a large-scale diligence project as a sole practitioner? Maybe if they go in-house, they might, or if they're a large law firm, they won't have to do that. But understanding basic negotiation skills, basic communication skills, those are all, I just say, endemic to any practice.
I completely agree. I think on the soft skills, you need to be able to communicate, whether you're in-house, outside, one person, 1,000 lawyers. Clear writing. We do so much by email. And just basic, I don't care where you are, don't use emoticons when you're talking to a client.
That's more of an issue than you think it is.
It is. We have an internal training class, is what every first year should know. It used to be called How to Survive Your First Year, and it's that's just one of the basic things. But I agree. I think probably our department level competencies that I talked about, that would need to be different, because you may not be writing a legal opinion. As Bill said, the practice is going to be different. So again, I think it's a combination. There are some things, just to be a good lawyer, you should be responsive. When you're in-house, your client is right down the hall. You need to be responsive. So I think it's there are things that apply to any lawyer.
Yeah, at the same time, I just want to throw out, I tried to make this point. I talked to a recent Harvard Law graduate who works at a major firm who said, I never would have wasted my time in law school taking a clinic or a skills course, because I learned all of that on the job. I have students I taught in my clinic who literally, this is not because they can't find another job, have said, I've always wanted to have my own practice. I'm going to take the bar exam and hang out my own shingle. And yes, they're going to be looking, and one in particular, he has some mentors lined up, but just walking through the motions of some of those basic skills, I think there's a huge variation. I have a question for the other panelists that gets into this. I'm dating myself, but there was an American Lawyer article, probably in the first years that it started being published, but it was made a big impact on me when I was a junior associate. They talked about partners in law firms, and there were 3 categories: the finders, the minders, and the grinders. So the finders were the ones that went out and found the clients, the minders were the partners who were the main contact with the client, and the grinders were the ones that did all the work. And basically said some people are good at some skills and some are good at other skills. I've known over my career a lot of lawyers. A lawyer who I worked with several years ago, he's now a general counsel. At his company, people love him. He was never the one I would rely on for the most thorough legal analysis before he gave an answer to a question. But everybody, he always told jokes, people felt comfortable in his presence, and personality was a really big component. And I'm not saying he did bad legal work, but he just never dug into the little details carefully. And that may be a very good position for him as general counsel, because he can still rely on outside counsel to dig into some of the details. But I'm wondering if this new set of competencies, is it still permitting people to develop so that some of the partners may be the finders and some may be the grinders, or is everyone trying to become a one-size-fits-all within a law firm by using the same set of competencies?
I'm retired. I can't screw up. I think at King & Spalding, I think the legal industry has evolved so that if you want to be an equity partner at a large law firm, you have to be both. You have to not only develop business for yourself and others, but you have to be excellent at delivering financial service. And if I look at the most successful people over the years at King & Spalding, they've had both. Now, there are people who have different strengths, and so you can do well if you are a great finder and you've got a good young partners behind you that get the work done, and those people can be successful, but the most successful people are the ones who do both. And the truth is, if you're only a grinder, you probably don't have a long-term career at a place like King & Spalding. So.
I'm agreeing with Bill all day, but I agree. I think it's not necessarily a one fits all, but the practice of law is so much more competitive, I think, particularly with, firms and clients and fee pressures. And I've been practicing for over 20 years. And I think, back then, if you stayed at the firm for the requisite period of time, you would make partner. You'd become the 6th year, 7th year, 8th year, and that just is not the model anymore. And that's why we have the competencies. it's not a negative if you don't become a partner at a law firm. That's the great thing about a law degree is you can do so many things. And so I do agree, if you're the grinder, you may not make partner, and if you do, you probably won't stay very long. You really have to have all, you have to be well-rounded, I think, as a partner, just like we want our associates to be well-rounded. And if they tend to fall in any one of those categories, then maybe they transition into a legal career outside, a big law firm.
I'll just add one postscript. Is one thing that's changed, particularly in the last 10 years, is we actually train lawyers, partners. We have client development, very sophisticated client development sessions for our clients, and we hired someone full-time whose job is a fancy job title, but he's basically a coach. I mean, he helps on responses for proposals, but he basically helps coach our partners, because we want people to be successful. So if you have what it takes to be a partner, we want you to continue to develop. You don't just become partner and that's you're off on your own trying to do something. So.
Time for one more question.
Hi, Rick Friedman from USC. Anne-Marie, I really liked your list of the 4 competencies, and the one I wanted to ask about was the teamwork competency. And as we're thinking about structuring classes, what are the things, successful practices in the classroom that put us in a position to be teaching or mentoring students on these skills, sort of best practices in doing practice assignments and group assignments? I was interested if any of you have any comments on that.
Well, obviously, working in teams a lot of times, and I think it's great if you have a law school class where, they're working in teams, and it's the type of project where everybody really would have a role. My daughter's in high school, and she always gets picked to be in these teams by boys, not because any other reason other than they don't want to work, and she'll work because she will not be a lawyer. She'll be the first to tell you. But, she's dependable. So I think it's good if you don't get to pick the teams. That would help. The specific things that we look for in teamwork, are they able to treat others with respect? This would be, a level 1. You regularly attend meetings of the team. You can demonstrate an ability to actually work within a team. We have found there are people that you would think they can work in a team, but they just don't. And the way our firm is structured, we actually have teams. I was a team leader. We have team leaders, and the responsibility of the team leader is to make sure that the work amongst the associates is spread evenly. We don't want somebody there till 9, 10 o'clock, and someone's leaving at 5 or 6 because they don't have anything to do. And so we'll monitor that work. But if we have, and part of the recruiting process is, and that's one of the things we assess in the interview, is if you have a star performer, some people just like to work better on their own. Give them their part of the assignment. They'll go figure it out. They'll come back and give it to you, and that's not the way we work. So anything that you can do in the law school setting, whether it's problem solving or giving a presentation. I mean, they work in teams in business school all the time. Most of what they do are in teams. And so that also, it generates not only camaraderie, but a lot more efficiency when you're trying to, it kind of goes back, to the importance of diversity as well. The more thoughts that you get on a project, the more efficient it's going to be. And we also think of ourselves as working as part of a team with the client, not just the outside advisor, but we want to be part of their team. And when you're actually part of the team and moving along together and not at different paces, it's more efficient.
And I just want to add that I had the chance recently to teach a contract drafting class, one class, at the business school, and I broke them into teams. It took a matter of seconds for them to just, boom, they were in their teams, and they were ready to work, and they had chosen a leader, which is really different from when I put my students in teams here at the law school. they're still not as comfortable with the whole concept, and they resist, and you have to kind of herd them around. Come on, 4 over here and 4 over there. It was an amazing difference. So I think we need to continue to work on that in the law school environment. Thank you, everybody, very much. It was great. Thanks.